let us start solving the questions of Indian Evidence Act. First of all, we read the quotation, इंतजार करने वाले को उतना ही मिलता है जितना कोशिश करने वाले छोड़ देते हैं। जितना छोड़ेंगे बस वही मिलता है। ये बात यहाँ पर कह दी गई है। चलिए हम लोग क्वेश्चन नंबर फर्स्ट की चर्चा करते हैं। ये कहा क्या गया है? Which of the following provisions of Indian Evidence Act permits evidence recorded in one case to be considered relevant in a subsequent proceedings? It means when an evidence is recorded, that evidence shall be also relevant in subsequent case. Actually, it is declared in the section 33 of Indian Evidence Act. Section 33 of Indian Evidence Act says that any evidence, if recorded, that shall be relevant in subsequent case. So the section 33 of Indian Evidence Act, here the correct answer of the question number first. Okay, this is the correct answer. So next question, in which of the following cases the evidence given by the witness will not be relevant under section 33? If any evidence is given by the witness, that evidence shall not be relevant under section 33 of Indian Evidence Act. In which case it is propounded? 33 of Evidence Act. In which condition it is? In which condition it is true? First of all, if you study section 33 carefully, the evidence given by a person shall be relevant when the witness is dead, cannot be found, witness is in coma. All these things are mentioned in the section 33. But when the witness is staying abroad, it is not mentioned, it is not propounded in the section 33. So the correct answer of the question is first. Not. It means if the witness is staying in abroad, his statement recorded shall not be relevant in subsequent cases, because at present time he may easily arrive in India. Section 33 says that if the witness is not found, is dead, in these cases, if any statement of the witness is recorded, that statement which is recorded shall be relevant in the subsequent cases. In these cases, so the first, it means A is the correct answer of the question number 2. A sues against B, yes, or recovery of debt. He shows intrigue because he makes some intrigue in the book. Intrigue in their account book as a ground that he is a debtor. This intrigue, that he, here the term should be he. He is debtor. Now, if we see here, A sues against B for recovery of the debt he shows intrigue in their account book as a ground that he is a debtor. This intrigue, if a person makes intrigue in the book that Mr. B is a debtor of him, it means such intrigue shall be relevant according to section 34, but it does not create any liability. It is mentioned in the section 34 of Indian Evidence Act. Here B, this entry is sufficient and relevant to impose liability. No, it is not sufficient for imposing liability, though such entry shall be relevant. Is relevant case where there is no any other evidence, yes, as a proof of debt, but not sufficient. Not sufficient. For what? Not sufficient to create liability, to impose liability. It is not sufficient. So, the correct answer of the question shall be B. If any intrigue is made in the book by a person, such intrigue shall be relevant undoubtedly if no other evidences are found, but it does not impose any liability to the person about whom here it is mentioned that if any intrigue is made in a book, such entry shall be relevant. Such entry shall be relevant, yes, if no other evidences are found, but it does not impose any liability to the person. So the correct answer of the question number 3 is B. Yes. Entries in the books of accounts regularly, yes, kept in the course of business. In the course of business, A book, a account of entries is kept, are admissible under section 34, yes, of Evidence Act. But if they by themselves create a liability, no, it is wrong. If they by themselves do not create a liability, it is also wrong. Actually, it is beyond to the creation of the liability. Whether the liability is created or not, it is immaterial. So, the correct answer of the question is C, irrespective of whether they themselves create a liability or not. This is the correct answer. Okay? This is the correct, because the liability, creation of the liability doesn't matter. It is not necessary. If the account in which entries are made, that shall be relevant, but it does not create any liability upon the person about whom entries are made. Okay? So the correct answer of the question number 4 is C. Next question. Which one of the following is a leading case on entries of account when relevant? R versus Govinda, no. It is relating to section 299 and 300 of IPC. Paklan Aram, it is also not connected. Moti Singh, it is not correct answer. Yes, L.K. Advani versus CBI, Lal Kirsh Advani versus CBI. In this case, actually, if any entries is made in the account, such entries may be relevant, but it does not create any liability. In this process, Lal Kirsh Advani versus CBI is the leading case relating to the section 34 of Indian Evidence Act. So the correct answer of the question 5 is D. Next. Which sections of the Indian Evidence Act deal with the proof of customary practices? Deal with the proof of customary practices. Which sections are relevant? Yes, customary practices, section 35, 48 and 49 is relating to the customary practices of Indian Evidence Act. These sections are relating to the customary practices. So the correct answer of the question is D. This is the correct answer. Next question. Which one of the following sections of Indian Evidence Act 1872 deals with the relevancy of the statements as to any law contained in law books? Contained in law books. It means which one of the following sections of Indian Evidence Act Section 38 that deals with the relevancy of statements as to any law contained in law books. So this is the correct answer of the question. Next, which one of the following sections of Indian Evidence Act has been substituted by the information technology? Yes, 39. Section 39 is amended and something is added in section 39 relating to the information technology. So section 39 is the correct answer. Section 39 is the correct answer of the question. Because which one of the following sections of Indian Evidence Act section has been substituted by the information technology? The section 39 is substituted through the Information Technology Act 2000. So the correct answer is C of the question. Next, the principle of res judicata is provided in which of the following section? In which section of Indian Evidence Act is relating to the doctrine of res judicata? That is propounded in the section 11 of CPC. Actually, there are those sections are section 40 of Indian Evidence Act. 40, it relates to section 11 of CPC, Article 20, Clause 2nd, and section 300 of CRPC. These sections are relating to some extent res judicata. So the correct answer here B, and other sections are also note down. So the correct answer of question 9 is B. B is the correct answer of the question. Next question, which of the following section of Indian Evidence Act 1872 deals with conclusive proof? Deals with conclusive proof. Which section? Conclusive proof means may presume, shall presume, and conclusive proof. When a fact is connected with other fact conclusively, when a fact is connected with fact in issue conclusively, it means that fact, if proved, this fact automatically shall be proved. This is the conclusive proof. This is the conclusive proof. So the correct answer of the question, section 14, 1 of Indian Evidence Act, section 112 and 113 also relating to conclusive proof. So it is correct answer of the question. And this is the 10th question. So A is the correct answer of the question. Yes, thanking you for watching this video. Okay, thank you. That's all.